Good afternoon, everyone. My name is Ezra Wohlgelerntner, and I am the Chancellor-elect of the Philadelphia Bar Association. I'm filling in today for our Chancellor, Kathy Jafari, who's on the road. I want to welcome you to today's webinar, sponsored together by the court and the Bar Association, and we are honored to host it. For all our members of the Bar Association who are participating, we thank you for your involvement in the Bar Association and for attending today's webinar. For those of you who are not members yet of the Bar Association, I urge you to consider joining. Currently, we have a special, so to speak. If you join today or now, you can have the balance of 2025 as a member, and the same membership fee will cover you for the year 2026. Membership is for both attorneys and non-attorney legal professionals. We have a wide array of sections and groups, most specifically to the area of practice of those who are here today. The state civil section is a very robust committee section with a subcommittee of a medical malpractice subcommittee. I've had the opportunity to co-chair that subcommittee years ago, and it's a wonderful opportunity to network with your fellow plaintiffs lawyers, defense lawyers, and the like. Please consider not only joining the Bar Association, but getting active in the Bar Association and its many committees. Membership in the Bar Association also provides exclusive benefits such as free legal research through a vendor of ours, Decisis, and that's a great benefit. It covers all states and jurisdictions, and there are also discounts for professional legal services, including e-discovery and digital forensic services. Today's webinar is really essential for every medical malpractice litigator and paralegals on both sides of the aisle. And we're grateful to the Honorable Judge Dan Anders for all the work that he has done to create an environment where lawyers practicing at this level have a predictable outcome, a schedule for the discovery of their cases and eventually trial. So we're grateful to the court for all the work it has done to make the Philadelphia Court of Common Pleas an exemplary model of efficiency and predictability. Without further ado, I'd like to turn the mic over to Judge Anders.
Ezra, thank you for that incredibly kind introduction, and we are happy to be in partnership with the Bar Association. You've been a great partner to us, and not only with the state civil section, but also in hosting these webinars. Today, we're going to do an update. It's been almost a year since we last had our last webinar, and provide some good information about our medical malpractice program and where we are as of this moment. And I can tell you that I am tremendously proud of the partnership that we have created between the bench and the bar, and as well as the hospital systems that have been supportive of this program since day one. Today's program, both Judge Schulman and I will lead off, then we'll have Denise Juliana, who will talk about the unique challenges in representing individual physicians and also small physician practice groups. Mr. Sherry will then talk about the JPT Settlement Conference and how to prepare for that to maximize the effectiveness of that conference, as well as looking at arbitration tips. And then finally, we'll end with MCARE's Beth Persun, who's a stranger to none of us, about the statewide perspective she has on handling medical malpractice claims. I'll start where I always start, which is how many cases have been filed year to date. Currently, we have 520 new cases that were filed in 2025. That's about a 1% increase from 2024. And at this point, it looks like we're stabling to a number around just around 50 per month. The year in review so far for 2025, as I mentioned, over 600 new medical malpractice cases will be filed by the end of 2025, slight increase from 2024. The trial dates that we are assigning at pretrial conference, you should know that you should expect to go to trial within 90 days if there's no reasonable offer that's made at the pretrial conference, or you do not provide your confidential authority to settle the case to Judge Schulman. If you do have either authority or you've made a reasonable offer, we'll give you the breathing room to try and settle that case between the pretrial conference and the trial. And generally, we're looking to schedule you within 6 to 9 months of the pretrial conference, absent some extraordinary or exceptional circumstances. And Judge Schulman can talk about that, what those might look like. In terms of the number of trials that were scheduled per week in 2025, you can see on a weekly average, we started just under 4. We dipped down to less than 3 per week in the second quarter, just over 3 per week in the third quarter. And you can see the rise of the number of trials per week. In 2026, we're already almost at 5 per week in 2026. What that is reflective of is the increased filings that started in 2023 and have continued in 2024 and 2025. Those cases are now starting to go to trial. And so we're going to see a sustained level of trial scheduled per week from the end of 2025 into 2026. That is comparing to 2024 when we had 5 to 8. We were clearing out at that point the COVID impacted inventory. What is the expected time to trial from the date of case initiation? So about roughly 90% of our cases are going to trial between 30 to 36 months after the filing of the complaint or writ of summons. If you have, like in this case that was filed in January 2023, you file no motions for extraordinary relief, you've timely exchanged your expert reports, and there's no offer at the pretrial conference, we will get you to trial much quicker than the 30 months. In this particular case that was filed in January 2023, it was scheduled for trial in March of 2025, which is a 26-month timeline from the date of case initiation to the date of trial. And that's a very important statistic to us because we want to keep these cases moving. No one benefits by having an aged inventory. That case actually happened to settle the week before trial. In terms of the number of medical malpractice verdicts, we expect to have 18 verdicts through the end of the year. I believe right now we have 15. That's my next slide. And that's compared to 30 verdicts we had in 2024. As I explained, 2024 was a catch-up year for the pandemic impacted cases. And 18 verdicts that we expect this year is consistent with the number of average verdicts from the last 10 years before that. In terms of the split defense plaintiff, again, 60-40 year to date, which is consistent with the roughly 10-year average of 62 and 38. One data point we started to keep track of this year is the number of transfers out of Philadelphia for either venue or forum nonconvenience. And year to date, we have 39. Last year, we had 29, both of which are much higher than the average of 19 transfers of medical malpractice cases for either venue or forum nonconvenience. That's really a function of the higher number of cases. I don't think we're transferring them out necessarily at a higher percent, but we're dealing with higher numbers of cases, so the number of transfers is also going to be higher. And note that this number does not include the number of transfers to binding arbitration. It's just venue or forum nonconvenience. In terms of the verdicts, those 6 plaintiff verdicts are reflected in the chart on top. One note I will make is that $14 million verdict was recently remitted. I don't remember the number, but it was below the $10 million threshold. And you can compare that to the verdicts, the plaintiff verdicts we had in 2024. As I said, I think we have 15 verdicts through the end of October. We'll probably get another 2 or 3, maybe 4 by the end of the year. What do we expect in 2026? I believe that we have leveled off in terms of the number of new medical malpractice case filings. And that new number is, as I said, roughly 50 to 52 filings per month. We expect to see an increase in the number of pretrial conferences and trials than what we had experienced in 2025. Generally, we were looking at 15 to 20 pretrials per month in 2025. That number will likely increase to somewhere around 30, maybe 35 some months. And as a result, we're going to be scheduling more trials per week. That will probably bump up to 5 to 7 trials per week scheduled. compared to the lower number of cases that were scheduled in 2025. Some of you may remember back in 2023 and 2024, we were scheduling up to 10 to 12 medical malpractice cases every week. So although it's an increase to 5 to 7, it's nothing that we've experienced before. And in fact, it's far below what we were scheduling for trial in 2024. The length of time from the pretrial conference to the trial date, we still have as a goal to schedule those trials within 6 to 9 months of the pretrial conference. If you have that reasonable offer or confidential authority to settle, and if not, then we'll schedule you within 90 days. And our goal is to get these cases to trial within 30 to 36 months of case initiation. In terms of the number of verdicts, it may likely increase somewhere between 20, 25 verdicts. I don't think it will get much higher than 25 verdicts, but we'll see how accurate that prediction is. In terms of double booking, and we do not want to double book you, but we also need to keep this inventory on time. And really, whether we double book or not, this is my last point, is up to whether cases settle. So we will continue to double book counsel unless cases settle earlier than they currently are settling. When we double book, the earlier attachment order controls, so the later attached case will be continued if the attorney is attached on 2 cases that are starting the same day. This has impacted less than 1% of the cases that are scheduled for trial. In other words, that the later case was continued. What we have done to try and accommodate when there are double attachments and they are both ready for trial is that we may delay jury selection for a few days to accommodate a trial attorney's schedule and to avoid continuing a case. We also, this last point that's bolded is, we will likely have, let's say, 24 med mal verdicts in 2026. If we only had to schedule those cases that were actually going to trial, I know that's unrealistic, but we only have to schedule those 24. We'd only schedule 2 trials per month. We'd never have to double book any trial counsel. Even if we double that to 4 trials per month, we would never have to double book any trial counsel. But the fact that there continues to be, there's definitely an improvement in terms of the number of cases settling and when they're settling, but there's still, in my view, far too many cases are settling on the courthouse steps or the week of trial. In terms of July and August, there will be no slowdown in terms of the number of trials that are being scheduled. We will respect any of your prepaid vacations, but we do expect to have full trial schedules through July and August. And the last thing in 2026 that we're hoping to do is to adopt some discovery protocols that a group of plaintiff and defense lawyers are working on together to make the discovery process more efficient and less costly. One big improvement that we've done this year is we have a civil calendar, and I'll show you for a second what that looks like, but you can go online to our court's website and click on the civil calendar button. And on there, you'll find a real-time listing of significant court events, including one-year conferences, pretrial conferences, trial date certains. It also contains the public docket for each case. It lists the lawyers who are there and the date and time of the conference. Separate from that, we have a 5-county trial attachment database. It's a different link. You'll see it also on the calendar section of the website. That is a real-time database of trial attachments for medical malpractice cases in Philadelphia, Chester, and Delaware counties. Soon to be added will be Montgomery and Bucks County. It provides the name of the attorneys who are attached, the case information, the number of trial days that they are attached for, as well as the dates of jury selection and trial. We have, Judge Schulman primarily has had a good cooperation from the leadership of the other counties who are trying these medical malpractice cases to work together to ensure that cases are not continued and that when you are double booked, that we're trying to work through those issues as best we can. I wanted to give you a perspective of why do we care so much about the age of inventory in moving these cases? Because the Supreme Court cares, and they have laid down a benchmark to have no more than 25% of our civil inventory to be more than 2 years old, and that we must move from an attorney-driven system to a court-controlled system. Now, you already know that in every medical malpractice case, the pretrial conference is 2 years in from the date of case initiation. So every single one of these medical malpractice cases will be older than what the benchmark has been set. We have to keep that number low. And in terms of statewide, you can see the numbers. 28.6% were more than 2 years old statewide. In December 2022, it dropped down to 19.9 in March of this year. In Philadelphia, we are doing great. We were at 21% in December of 2022. As of this past March, 8.7. And from a historical perspective, we've never been lower. The lowest I could find was back in 2014, where we were at 13%. And if you look at just before the pandemic hit, we were at 27%. And at the height of the pandemic, we were at 32%. So we are doing incredibly well in terms of moving our cases and getting our cases to trial. And with that, I will give it over to Judge Schulman.
Thank you, Judge Anders, and good afternoon, everyone. So the way we keep the inventory moving is my job, and the devil is in the details. So I'm going to try my best to go through some of those details with you. We have our one-year conference I conduct along with help from Peter Hoffman. The thing to remember about a one-year conference is that all written discovery should be complete, answers complete within 1 year. You should be scheduling your depositions by the time you get to a one-year conference. Because if you let yourself get behind, of course, you may end up not being able to meet your discovery deadline. So even if you don't have every last piece of written discovery, you can still get those deposition dates on your calendars while you're waiting. And do not stop discovery because you have venue preliminary objections or any other kind of preliminary objections. Venue does not concede, participating in discovery does not concede venue. Check the rules. It does affect jurisdiction motions, but not venue, so you should continue your discovery. On our at any point in time, you can ask for a JPT settlement conference. As many people know, they are extraordinary people, the leaders of the medical malpractice bar who conduct these settlement conferences. They do it pro bono. It's a tremendous service to the court to help us to get cases settled easier. You can request a JPT conference at any time in the litigation as long as there's been a reasonable demand and a reasonable offer or communication of your authority confidentially to me. You can contact my chambers once that happens, and if you're interested in a JPT conference at any time. As far as trial readiness conferences, I conduct those on Mondays and Fridays before jury selection. We'll discuss the status of motions in limine, the trial schedule, and the status of settlement conferences, settlement discussions. Trial counsel must attend. It's not okay to send somebody to a trial readiness conference who doesn't know what the case is about. So we do ask that trial counsel attend. And if there are a lot of motions in limine, I might ask one of the lawyers to prepare a short brief that outlines the chronology that the parties need those motions to be decided. In other words, if there is a dispositive motion, you're trying to knock out someone's expert on liability, that motion you want to highlight and make sure whoever is going to try the case, whoever you get assigned to, is keyed in to what you think is the most important, are the most important motions to look at. We can move to the next slide. The pretrial conference is really and extensions of those issues are what I want to spend the most time on. So keep in mind, I do all of the pretrial conferences. I have 1 week out of every month where I do the one-year conferences, the pretrial conferences, as well as the rule hearings. So when you're doing your pretrial conference memos, well, let me first get to start with the pretrial conference only gets scheduled upon the filing of a certificate of compliance that all expert reports have been exchanged. So you know that once the discovery deadline is up, plaintiff's expert reports are due 30 days later, defendants 30 days after that. Once defendants experts are exchanged in total, and all parties' experts are exchanged in total, the plaintiff's counsel files the certificate of compliance. And that's what triggers the scheduling of your pretrial conference. So if you're behind on your expert reports, your pretrial conference is going to get delayed. If the plaintiff is waiting for defense counsel's expert reports, the plaintiff's counsel can reach out and ask that the pretrial conference gets scheduled anyway. And that does happen from time to time, and I consider those requests when they're made. If the certificate of compliance is not filed, a rule hearing is triggered. So that's automatic. 10 days after the deadline for expert reports, a rule hearing will get scheduled. We'll be notified, but that rule hearing won't happen for another 30 to 45 days because both sides are allowed certain periods of time for notice and because of the court's schedule. So keep in mind that the rule hearing, the only purpose is that there is a failure to exchange expert reports. If you exchange your expert reports before the date of the rule hearing, you can always let my chambers know. We will cancel the rule hearing. You don't have to come, even if it's the day before the rule hearing. And I don't want to tell you how many times that happens, but it happens a lot. So the day before, if you have your expert reports exchanged, contact my chambers, let us know that, file your certificate, and we'll cancel the rule hearing. If they're at the pretrial conference, there are 3 things that defense counsel is required to do. Number 1, they can make a reasonable offer to settle the case. Number 2, they can communicate confidentially to me what authority they have to settle the case. Number 3, they can say, this is a no-pay case, Judge. We're not paying on this case. We just need a trial date. The reason for this is that in between the exchange of expert reports and the pretrial conference, we allow a 90-day period. That 90-day period is baked in so that the hospitals and the carriers and defense counsel can conference the cases, decide what they want to do, so that at the pretrial conference, I have those questions answered. What should not happen, it does happen all too often. What shouldn't happen is, gee, Judge, the case still hasn't been conferenced yet, and I can't tell you what our client's position is going to be. Then you're going to get bumped into, all right, you're going to trial right away. Your trial's ready. You're not trying to settle the case, and you should expect to get a 90-day trial date if possible. If you are, as Judge Anders said, making a reasonable effort to settle the case, I'll push your trial date out further to give you time to do that. Certainly, at the pretrial conference, a JPT can be requested. That's often when they are requested and scheduled. And before the pretrial conference, you are expected to meet and confer with one another on possible trial dates. Please don't wait until you get on screen with me or with my staff the morning of your pretrial conference or at the time of your pretrial conference to do that. The earliest possible date is what we are looking for. You have to know your availability of all of your witnesses and keep in mind that trial dates will not be rescheduled because of the effort that it takes to get a good date. They won't be rescheduled absent extraordinary circumstances, like someone is ill or someone has passed away or something of that nature. And it may have gotten cut off a little bit, but you should certainly by the time you get to the pretrial conference, where notice of a claim has been made to MCARE, all parties' pretrial conference memos should be submitted to MCARE by the party giving notice to MCARE. I typically will not continue a pretrial conference for unavailability of counsel because they won't come up for another month, and that's prejudicial to the other parties. So again, extraordinary circumstances have to exist to continue a pretrial conference. Same with the expert report deadlines. I get a lot of motions to extend the expert report deadlines, and if you filed them, I'm sure you've experienced that 90% of them are denied. And that's because you do have time up until the rule hearing to be in compliance. So if there's an extraordinary circumstance, such as, I think we had 2 last week, an expert passed away or an expert suddenly is having cancer treatment, those are extraordinary circumstances, and I will give you more time. Otherwise, you should expect that you're going to comply with these time schedules. And I think that the last thing I want to mention is about the pretrial conference memo. So remember that I'm reviewing these cases, I do maybe 70 in 2 days. So please keep what I'd like you to do with your pretrial memos is start out with an executive summary, set forth plaintiff's theories of liability and causation, defense set forth your theories of defense, right up top. So I'm not reading through 10 pages to get there. Please, plaintiffs, put the age of your client down. Obviously, that affects settlement discussions. And when you do recite the facts, I'll just say 3 lines are probably not enough. 25 pages is probably too much. You don't need to reproduce the entire medical chart. Lay your case out in a concise manner, and I think you can get your point across to opposing counsel that way as well. And then I just wanted to note that you'll see on your case management orders, the first order that comes out, there's a little extra notation about summary judgment motions. And we have made a little change that defense summary judgment motions are not due until 30 days after the last expert report from plaintiff has been exchanged. So you'll see a motions deadline on your case management order, but just keep in mind that if plaintiffs are late with their expert reports, then the defense will have 30 days from the receipt of the last one in order to file a summary judgment motion. I think I've covered it all.
Thank you, Judge Schulman. I want to emphasize the last point of the slide, which is providing the copy of the pretrial memo to MCARE where notice has been provided to MCARE. The amount of effort that MCARE has to go through currently to get basic information about the claim, the defenses, and the medical treatment is astonishingly, it's still way too, it's not complied with. And so the best friend in this, if it's an MCARE case, is going to be providing MCARE with all the information that you have about the case so that they can evaluate it when and if a tender is then provided. So provide them with the notice when notice has been provided, make sure that they get a copy of the pretrial memos. Just a few more quick cleanup. Notice to court of the settlement. As soon as your case settles, you've reached material agreement on all points, and that's when you need to notify us that the case is settled. Don't wait until the settlement petition is filed, if it's filed in orphans court. When you've reached material terms and you've agreed to those, that's when your settlement letter should be filed with the court, not waiting until the end. And then there's a slide on MCARE's evaluation, which I won't take time to read now, but that will be in the materials that we provide. And I want to do one last thing before I turn the program over. I will show you how easy it is to go onto our court's website and find this calendar information. So under this calendar tab, you can go to the medical malpractice trial attachment tab, click this link that says trial attachments, and right there you will see everyone who has the trial with the date of the jury selection, how many days it is to try. You can download this file. If you want to search a lawyer's name, and I'll pick on Ms. Romanowitz, you will search the tab and it will tell you every case that Ms. Romanowitz has listed for trial, and she has several, and it will list everyone who's on there. It has the Chester County and Delaware County attachment information as well. If we go back to the main calendar, under Common Pleas Civil, click the button, go to the bottom where you accept, type of hearing list. I want to look at 1-year conferences, and I want to look for medical malpractice cases. Type in the dates. We'll do it from today through, let's do a couple of months here into the end of this January. And this will show you every case that has a 1-year conference. It'll show you the date and time, the caption. This case ID will take you to the public docket. It has all the names of the lawyers who have entered their appearance, and you can see that Judge Schulman has 40 1-year conferences scheduled in the next 60 days. You can look at pretrial conferences. So here's pretrial conferences, settlement conferences, rule returnables, case, anything that you want to look at in terms of our scheduling system or scheduling for civil cases is present on our court's website. If you think there's something there that is not there, let us know. But we think that this has been a valuable tool for folks to use. And I do want to, if we didn't say it, over 500 people registered for this event. This shows, I think, the need for this information, and over 470 people have actually signed on. So I greatly appreciate everyone's attention. And with that, we will turn
Judge
over.
Anders,
Yes.
I left something out. If I can just go back, one item I wanted to talk about was double bookings, and that's important. So if you are double booked and you see that 2 weeks before the trial, it's typically defense counsel, that your case your 2 cases are still going forward. I'm asking that you send me a letter 2 weeks before your trial listing or 2 weeks before the trial readiness conference. Set out the 2 cases, identify the case, identify the county where the case is located, so that I will and other counsel will continue to track your case up through the time of the trial readiness conference. Okay, thank you.
All right, and with that friendly introduction, where do we see her? Denise, there you are.
Good afternoon, everyone. I do not have a nice PowerPoint presentation, so you're stuck looking at me. I want to thank Judge Anders and Judge Schulman for giving me the opportunity to speak about what are some unique challenges in representing physicians and the physician practices. Having spent the last 30 years defending doctors, I think what is often overlooked, or what the difference between representing physicians and hospitals is the very personal and emotional aspect to the physicians when they're involved in a lawsuit. Physicians are real people, they're not institutions, and everyone always is aware of the emotional aspect to plaintiffs, but they don't consider, I don't think a lot of people consider, that there certainly is an emotional aspect to these lawsuits for the physicians. And I think as their attorneys, that's something that it's very important that we take that into consideration. In fact, oftentimes it's emotional from the beginning when the physician's involved. The very treatment that gives rise to the lawsuit, if there's a bad outcome from surgery, if a patient died, that can be traumatic on the physician as well, not just on the patient and their family. So I think that needs to be taken into account, the fact that there is this emotional toll these lawsuits do have on the physicians. Then they after the medical experience, then within 2 years, they're getting notified of a lawsuit. And obviously that causes a lot of angst. And a lot of them get angry about that. They've spent a lot of time and money going to law school. They've had years of training. They've all taken an oath to do no harm. And now their very livelihood is being attacked. So it's very difficult for them. Sometimes we're even the bad guys because they don't want to take a day off from work to schedule a meeting with us, take a day off to schedule their depositions. So it definitely presents challenges. When the lawsuit is filed, and I think it's important to point out that by the time we get on board, plaintiffs' attorneys have already had the case for up to 2 years. They've already had the medical records for up to 2 years. They've got their experts on board because they have to file their certificates of merit. So right off the bat, we're starting from behind the 8 ball, and it takes us time to get medical records. If the hospital is a defendant, we have to wait for them to enter their appearance. Sometimes it takes them a long time to get records from their client, and we can't get the records from hospital counsel, obviously, until they get the records themselves. So that can take time. That can take several months sometimes, even longer if the hospital's not named, but those records are important for our evaluation because now we have to serve subpoenas on the hospitals. And yet oftentimes we're getting requests for our clients' depositions from plaintiffs' attorneys, and we haven't even had a chance to meet with our clients yet because we don't have the pertinent records. The one issue that's come up a lot in discovery, and it's a very hot topic, and I think it's something that we need to speak about, that Judge Anders has asked me to speak about with respect to physician practices, and that is the audit trail. It seems to be nowadays that plaintiffs' attorneys think that the audit trail is important to see in every single case, regardless of whether it's relevant. Well, that presents a huge challenge to physician practice groups or even some of the smaller surgery centers. Oftentimes, those audit trails are controlled or maintained by an outside EMR company. So we have to request them from the outside company, or our clients do. Those outside companies don't often respond. And I actually in the past have had to subpoena those outside companies just to get the audit trail for my own clients. So it's not just a simple discovery request where one of our client can just push a button and print it out. It's a lot more involved, a lot more time consuming. And I've even represented physician practices who ask me what an audit trail is. They don't even know what it is. So it's definitely a challenge to produce them, and not necessarily needed in every case. The other issue that is very, well, I think it's quite different for physicians versus hospitals, is the way settlement is approached. And for most, if not all, malpractice insurance policies. There's a consent clause for the physician. So a case cannot settle. There will be no settlement discussions unless the doctor consents to settle. And it's his right. It's his or her right to do that. So if the doctor does not want to settle, and the emotional aspect that I talked about earlier often comes into play with this, the doctor is convinced, feels very strongly that their care and treatment was appropriate, and they're not going to settle. So those cases they won't settle. And if we have strong expert reports, the cases are not going to settle. And contrary to what some may believe, not every case should be settled. Obviously, there are a lot of cases that are quite defensible, regardless of how bad the damages may be. And so those are cases that aren't going to settle. But once a physician does consent, then those cases obviously are evaluated for settlement purposes. And that takes into account, obviously, the review of the expert reports. And most carriers are not opposed to, early settlement, but it does not help anybody when we receive ridiculous demands of, maybe a $15 million demand where there's no wage loss, then there's no meds to board, or plaintiff's attorney counts up how many policies are at issue in the case and just makes that demand regardless of whether or not there's any rational basis for it. So that really does not advance the ball at all, and I think is rather counterproductive. But when the physician has given their consent, and when we've looked at the case, and it's one that we look at for settlement, most carriers are willing and very interested in pursuing the ADR options. We've done lots of high-low arbitrations and mediations, and I think they're becoming more and more common over the years. So that's definitely something that we've pursued in the past, and I'm sure we'll continue to pursue. So I think that would be a good time for Dan Sherry to step up now and talk about that.
Thank you, Denise. And my twin, Dan Sherry, is taking over my name as well, but that's okay. I think that's an honor. So, Mr. Sherry, and you're on mute if you haven't unmuted yourself.
I don't know if you have heard what I said before, it wasn't that important. So my topic is dealing today with JPT conferences, and then secondarily with private ADR, mediations and arbitration. And just so you know, this is not an effort on my part to promote or show my own services. That you all know that there are a tremendous number of really fine ADR folks out there who can definitely help you out in different cases. My wife did tell me that what I should tell you all is that I'm a terrible, terrible judge pro tem, but a truly wonderful, outstanding arbitrator and mediator. But I'm not going to tell you that. So just so you know, for both JPT conferences and mediations and arbitrations, one size does not fit all. You should know your JPT or your mediator or arbitrator. And if you don't know her or him, ask someone. You have listservs and you have other means available to you to vet someone and to see what they like, what they don't like, what they need, and what they don't need. So take advantage of that. Judges Anders and Schulman have already told you what's necessary to get a JPT conference, so I'm not going to repeat any of that. For the JPT conference, you probably don't have a lot of flexibility on the date for the conference, and for ADR, that's certainly a lot more flexible. On submissions for the JPT conference, for me, frankly, less is somewhat more. if your memos adequately summarize the records and the expert reports, I don't need to read those. For mediations and arbitrations, send me what you think, whatever you think I need. And especially in the arbitrations, share those documents with each other before I see them, so I'm not getting something that will later be the subject of a preclusionary motion. For JPT conference, I don't require the parties and claims folks to be on the Zoom call, but I do insist that they be immediately available by telephone or email or other means. For the mediations and arbitrations, I prefer folks participating in person, but I know that's not always possible, especially when claims people may be on the the left side of the left coast of our country. So whatever works for everyone works for me. I do prefer arbitrations in person if possible, because I like to evaluate not only the person testifying, but the other people in the room and their reactions to certain testimony. For both the JPT conference and the mediation, I would like to know in advance the status of the negotiations, what the last offer and demand were, and who made the last move. Of course, for an arbitration, please don't share any of that information with me, although in doing so, you would probably make my job a lot easier. Probably my most important message today is that for both a JPT conference and a mediation, if there are multiple defendants represented by multiple defense counsel, please try to work out in advance percentages of contribution. It's very frustrating and non-productive to keep the plaintiffs waiting while we're haggling over those percentages. And to me, that's just a recipe for the session not being productive. For a JPT conference, there's no need to do any openings. I've read your materials. I know your various positions. And for the mediation, not really necessary for me, but sometimes you may need to do it for your clients or for the claims person. So I'll share just one war story, and I promise you it's the only war story today. I had a mediation a few years ago, and the attorneys agreed there'd be no opening statements, and the plaintiff's attorney, terrific attorney, said to me, "I just want to thank everyone for being here." Well, he thanks everyone for being there, and then 45 minutes later, he has proceeded to excoriate everyone in the room, including myself. And when he was finished, the defense contingent stood up and walked out of the room. Now, I got them back in, and we actually were able to get the resolved. But I asked him here, I said, "What did you do?" And he said, "I don't know." He said, "I just started and I couldn't stop." So be careful about even thanking the other side for being there, because you don't know what it's going to lead to. Probably the biggest difference between a JPT conference and a mediation is confidentiality. So in a JPT conference, I do have reporting obligations to the court, so I can't give complete confidentiality to the process. I do try to refrain from giving a lot of details about what took place, and especially to refrain from throwing one or more of the attorneys under the bus, even if one or more of them should have some tread marks on them. For the mediation, there is confidentiality to the entire process if the case doesn't settle. And for both, there will be confidentiality to our individual discussions. I take confidentiality very, very seriously. And in my experience, it's the only way mediation or JPT conference can be successful. So how candid should you be regarding your bottom line settlement or your settlement authority, what your bottom line settlement number is? In an ideal world, you would share that with me. You would tell me what your line in the sand was, or what your the extent of your authority, and actually be truthful about telling me that. What is that old hymn? Wonder of wonders, miracle of miracles. But we don't live in an ideal world. At least I don't. So I don't expect you to share that with me. And often, frankly, defense counsel, they're not privy to the authority that the claims person has. There's no magic to the format in either JPT conference or mediation. I just, we have an initial session in a mediation, and then I just go back and forth. And My style is not to push. I don't push in either a JPT conference or a mediation, but I try to suggest, and maybe I nudge a little bit. In a JPT conference, I'm more likely to make a settlement recommendation, less willing to do so in a mediation because it really takes me outside the role of being a mediator. If we get close in a mediation, I can give what's called a mediator's number, and that's usually if we're just within, say, 5% of each other. But I give a lot of caveats doing it, and again, I prefer not to do that. So if the JPT conference doesn't result in a settlement, I can and I will stay involved if everyone agrees, and I can follow up with telephone calls. About 50% of the conferences I do will settle during the conference, and about 95% of the balance of the cases will resolve at some point. The point is that the great majority of cases will settle, given the appropriate attention and the appropriate amount of time. So if a case doesn't settle, frankly, I don't beat myself up over it. If I have brought the parties closer together, I feel like I've done my job. I think at the very least, you see how the other side evaluates their case. They see how you evaluate your case. And hopefully the mediation isn't just an exercise where one side is telling the other side just how lousy their case is. And my experience has been that people come to these conferences in good faith and with a genuine desire to try and get the case resolved. For arbitrations, I'm not going to talk much about that other than I want the parties to feel like they've had their day in court, so to speak. And I am very reluctant to cut off someone, even if they're probably not really helping their case. They want to feel like they've had the opportunity to be heard. So I'll close by saying, why do I do JPT conferences? I do them on a periodic basis because it's my way of thanking in a very small way the court system generally for what was for me a very fulfilling career, almost 50 years at the Marshall Dennehy firm, and having the privilege of trying a number of cases, a lot of them medical professional cases. And it's also specifically thanking both Judge Anders and Judge Schulman and their staffs for all their efforts to try and get this system under control. And I appreciate your attention. Thank you very much.
Thanks, Dan, and thank you to all the JPTs who have participated. It's really been a very successful program. A few years ago, and I think I may have mentioned this at another webinar, but a few years ago, I was meeting privately with just the hospital systems and their lawyers, and I was stressing to them, why can't these cases settle earlier than the courthouse steps? And at one point, one of the in-house counsel interrupted me and said, do you want to know why we settle on the courthouse steps? I said, yes, please tell me why. And he said, because that's when we pay the least amount of money. And I said, great, well, that makes sense. I would want to settle when I can pay the least amount of money too. The next morning, I had another conference call, this time just with plaintiff lawyers. And we're going through and I say, why can't these cases settle earlier? Why do they have to wait until the courthouse steps? And a very well-regarded plaintiff lawyer says to me, do you want to know why these cases settle on the courthouse steps? I said, sure, tell me why. And he said, that's when we get the most amount of money. And he pounded on the table. He said, we get the most amount of money at the courthouse steps. And I said, well, that's funny because just yesterday, the defense lawyer said that's when we pay the least. And he looked a little puzzled, but that is when you settle. You settle when the defense thinks they're going to pay the least and the plaintiffs thinks that they're going to pay the most. And I promise you that doesn't always have to be on the courthouse steps. That can be, as we've built this whole system around, when there's a fair evaluation of all the expert reports and all the other discovery that you've taken in that 90-day window between the scheduling of the pretrial conference and the pretrial conference itself. That's the sweet spot of settlement. And you can avoid costs to your client in preparing for trial. You can avoid the headache of being double booked. Maybe you can go on a vacation. If you can prioritize the cases that should settle, and then let's try the cases that need to try. We're happy to try your cases, but please, if you can settle cases earlier, it really takes the pressure off all of these double bookings of lawyers. And without further ado, the really key part to this whole process across the state is Beth Persun.
Thank you, Judge Anders, Judge Schulman. I don't know about the key part. You know, we're the government, and you know, now we're going to get into some boring details. I wish I had some jokes to tell you, but boy, I'm fresh out. I think I'd leave that to Dan Sherry. So thank you. Good afternoon, and I appreciate being here with all of you today. I'm going to share some of MCARE's 2025 claim year results, talk about our ADR program, which is a hallmark of what we do to try to early resolve cases or get them done in the right way. And then some additional information about MCARE, especially for those who are not as familiar with the MCARE fund's role in medical liability coverage and our claims operations. But before I start on that, I do want you all to know that we want to be of service to all of you. And hopefully you will take us up on that offer. I'm hoping that I share some things. They're at a very high level, but we invite you to contact us and find out more, reach out. No question is too basic for us to answer. And so we would appreciate hearing from you. So by way of background, just to start us off on our claims results, I want to remind those or let those know who don't know that under Act 13 of 2002, healthcare providers are required to obtain primary medical professional liability insurance of $500,000. MCARE is excess to this coverage, providing an additional $500,000 above for a total of $1 million. And that's per participating healthcare provider. The claim payments MCARE makes are paid through assessments of fund participating healthcare providers. All hospitals, physicians who are practicing more than 50% have to participate, nursing homes. And then you can look at the act to see what other healthcare providers are participating. And we have a compliance program to be sure that they are participating in order to protect the healthcare provider and victims of malpractice. So beginning with our claims results for 2025 year, the statutory year for MCARE claims payments begins on September 1st and runs through August 31st. With finalized claims, and that would be through a release that is received in our offices that has prescribed requirements and that we have court approval, but all finalized claims being paid to claimants and their legal counsel will be made this December 31st. We do that each year. And so the 2025 claim year concluded at a total of $247 million in payments that we are scheduled to send to claimants counsel on December 31st. And then this amount reflects 542 claims represented in 362 cases. The prior year, our 2024 year, totaled $275 million. The clearing of the pandemic backlog, which Judge Anders spoke about across the state, had a significant impact on claims payments at MCARE from the later months in 2022 through claim year 2024. And this catch-up fast-tracked cases and the total number of resolved claims increased. That resulted in claims payments in 2024 being that $275 million. The majority of claims that were settled in our claim year 2025 were those with filing dates after January 2023. Now, aside from straightforward settlements and trials, ADR is regularly used in Pennsylvania Med Mal, as Dan had talked about. And since 2003, MCARE has promoted these methods, and we have a very active program assisting defense and plaintiffs in early resolution cases. I'm very proud of this number. MCARE has been involved in over 2,900 of these processes since that time and completing an average of 150 per year. So this is a long proven way of effectively resolving your cases, and we hope that you will consider alternative methods well before trial. This past year, parties concluded with us 110 mediations and 45 binding arbitrations and trial agreements. So you can see that these methods are used very often and they have a high level of success. And this isn't even the most extreme cases. So we want you to consider this. Now, there's mediation and arbitration. I'll first talk to mediation. A few key factors when MCARE is involved in a mediation is that at least one party should come to the table with money and an effort to globally resolve the matter. However, if a case does not conclude at the mediation, to us, that's not an indication of an impasse. The measure of the effectiveness of that process is that greater communication occurred between the parties. They came together for an event. You know, it still makes a difference just getting face to face with people when you have a conflict that needs to be resolved. And so frequently, if the case does not resolve at mediation, it does have the effect of resolving shortly thereafter, or everyone at least knows why they're going to trial. Now, with binding arbitration, there are detailed agreements that parties and all the payers sign. MCARE drafts those agreements. And we've been doing this, like I said, since 2003. It's a very sturdy program that is well endorsed across the med-mal community. So we would like you to consider that that might be key for your case. We have about 40 to 50 average per year, and that takes the cases out of the court system and to a conclusion, importantly, that everyone has already agreed on because you've signed the arbitration agreement. So if you'd like to know more about ADR and in med-mal cases, we would like to talk to you and again, would like you to reach out. Now, we see lost opportunities to consider alternative strategies that happen simply because the timing pressures of trial or moves that another party makes in your case, it changes the way it resolves. A co-defendant might join tort out or produces an expert against your client. And that will change how things occur. And we know typically it might increase the cost. But before this occurs, earlier collaboration through either a mediation or just discussion, we can have defense party mediations, bring a greater awareness of everyone's position. Now, the attendance on this webinar is very high, and many of you may not be familiar with MCARE, as I said earlier. And so I want to talk about what triggers MCARE's involvement. And we have two important factors that we want to bring to your attention. And again, reminding you, we are excess coverage. The first is establishing a notice of claim. What establishes that? Well, an initial notice of claim can only be submitted to MCARE by the primary insurer. Receiving that notice from the insurer is an acknowledgement that they are providing the primary insurance for the claim. And there's a prescribed form on our website. This should be sent at the earliest point where the insurer determines that the damages being asserted have the possibility of exceeding their primary limits. Thereafter, they are responsible for keeping us aware of developments. A tender is distinctly different than a notice. A tender is a written commitment that's provided to MCARE by the insurer of their full primary limits of $500,000, not less, unless there's an aggregate limit issue, but it should be $500,000 per occurrence for use in settling the claim in payment to the claimant. and only the insurer who reported the claim to MCARE is obliged in their limit, and they are the only ones who can tender. When this tender is received, it triggers MCARE to begin an evaluation. We have highly experienced claims attorney examiners that are handling these cases. And then from this point forward, MCARE controls that primary limit and the MCARE excess limit. And we are not financially obligated before this time to become actively involved. So the notice itself is not enough. I will mention that insurers should consider tendering their primary limits when discovery has made it evident that a case exceeds the primary settlement in primary limit in settlement value. This is particularly important in the summer months when the parties are trying to late resolve before the MCARE August 31st deadline. August tenders have a risk of not being reached, especially in cases that are just being reported. They're being late reported, and the volume demands that MCARE has in those months may not make it possible. And again, coupled with what Judge Anders and Judge Schulman said, which is not getting us the pretrial report and some evaluation reports up until that time. So as some may know, we did have some cases. We could not reach this past August due to the lateness of insurers, and we cannot compromise our procedures. I'd like to mention the MCARE assessment rate for next year, which is most interesting to the insurer representatives that are on the call. MCARE is a pay-as-you-go system with its claims payments from the preceding claims year being the largest factor when determining the assessment percentage. The assessment rate that the participating providers are required to pay to MCARE is calculated in the fall of each year. So we just finished that process because we had our end of 2025 claim year numbers. And we published our 2026 assessment rate in the Pennsylvania Bulletin on October 27th. The rate is consistent with 2025's rate of 29%. Now, even though the 2025 claim payments were lower, they were 247, decreasing when compared to the 2024 number of 275 million. That rate remains at 29%. As a result of we repaid a loan that we had to take from the AutoCAD fund to pay 2023 claims. Lastly, the MCARE fund has the distinct purpose of providing this coverage I spoke of to participating healthcare providers and then compensating victims of medical malpractice. And we take these responsibilities very seriously. We want to be in service to the med-mal community. So we encourage you to contact us with questions, and we're glad to provide information on medical liability coverage in Pennsylvania and the MCARE funds processes. Thank you, Your Honor.
So I want to thank everyone who participated in the program today, especially to Ezra and the Bar Association and their staff of helping us with this webinar. And so on behalf of Judge Schulman and the rest of the speakers, thank you for participating. If you have any questions or follow-up, I am an open book. Judge Schulman is an open book. Feel free to call us. We do not want this process to be we want it to be transparent, is what I'm saying. We don't want it to be difficult for anyone or make anyone's job or any more difficult than it already is. And so I think we've been very successful in the last 2 or 3 years of moving these cases forward, gaining control of our inventory, and doing it in a way that hopefully is rational and makes sense for folks, and also giving you, for the business side of this book, some predictability of when cases are going to go to trial and what we expect in terms of settlements and evaluation of cases. So thank you very much.